Good afternoon. This is Judge Alyssa Perez resuming the criminal docket for the 210th District Court for October 19, 2021. All matters being heard today are being heard in accordance with all emergency orders and directives regarding COVID-19. In addition to that, we are streaming all matters live via YouTube for public viewing. Mr. Sarno, would you call our first two cases?
Yes, Judge. State of Texas versus Randy Alexander Martel, cause number 20210D00640. State of Texas versus Christopher Rick Martel, cause number 20210D00641. Announcement of counsel, please.
Brian Herrera for the state of Texas. Ready, Your Honor.
Good afternoon, Your Honor. Felix Valenzuela for Randy Martel, Joe Spencer for Christopher Martel, standing in for Felix Valenzuela, Your Honor.
Thank you very much. We are here for a status conference, and I have it down as a motion hearing. Assuming that is the continuation of the previous motion to inspect, if I'm not mistaken. But gentlemen, can you give me an update? I do see that we have our December trial off the calendar now. So we're operating with that April trial setting. How are we doing?
Yes, ma'am. So, Your Honor, on October the 12th, we probably had about a little over a 3-hour evidence review. Ms. Hill and I met with 6 other crime scene unit detectives and went over all of the evidence that was left. I took extensive notes and wrote everything down. I gave Mr. Valenzuela a brief rundown of what I had reviewed. In fairness to Mr. Valenzuela, Your Honor, this is what has to happen. I have to sit down with Mr. Valenzuela, and it's going to take several hours. As you know, he's in trial in federal court, so he has not been able to spend some time with me on going over this evidence review. Ms. Ceniceros from the DPS lab was there. She was asking about the number of items we were going to want tested. I could not tell her at that time because I still have to review this information with Mr. Valenzuela, but I could tell her that it was going to be more than 10. I then suggested to her, and she agreed with me, that when Mr. Valenzuela gets out of trial, and it appears, Your Honor, he'll be out early next week or late this week. It's going to be a little shorter than what we thought. We're going to get together, go over the areas that we think we need to have tested. We're going to go and have a visit with Ms. Ceniceros at her DPS lab so that we can explain to her what we're looking for, what we're asking for. And she at that time said she could tell us how much time she expects it would take for us to have the results. She said, depending on what we wanted, most of it would be under her control. Some of it may be not under her control and maybe under another lab's control that might take a little more time. But until we meet with her, she's going to be in a better position to tell us what type of time frame, because I know that's something the court wants to know as much as we want to know, how long it's going to be before we get this evidence back. It was very helpful, Your Honor, to sit there and go through all the evidence, and we were able to do that with the protocol that the crime scene was comfortable with and identify all of those areas. I just have to debrief Mr. Valenzuela thoroughly and go over that. I anticipate it will take us a couple of weeks to do that, and then maybe a week to set up a time with Ms. Ceniceros to go over that with her. My suggestion, Your Honor, if maybe we could have a status in 30 days, I could give the court much better direction based on whatever feedback I get from the DPS lab.
And that was going to be my question. I wasn't hearing it if it doesn't look like it's going to be in time for our next setting. So unless you need that November 4th setting, either of you all, I'm wanting to, or unless you think you can have an answer by that date, I want to reset the 11-4 final judges conference. Let's go to 11, is it 16? November 16th at 3 p.m.?
Yes, ma'am.
Okay. Does that work for you, Mr. Herrera?
Yes, Your Honor.
Okay. All right.
And by that time, Your Honor, we'll have all the information we need of the time frame, and then we'll make a determination of whether we're going to re-urge our motion for the bond for our clients,
Yes,
depending what we hear, and we'll be able to give you a much more greater detail. But I do want to thank the court for the effort it made to get this done. If the court had not stepped in, I don't think we would have been able to have gotten as far as we've gotten.
Yeah, we've been making good progress. Thank you both for all of the extra work and trying to move this along. We will have that reset, but in the interim, if something comes up, obviously, please contact us so we can get you a hearing before then, because that'll put us right before the Thanksgiving holiday, and then things get really complicated with Christmas coming up right after that. So,
We had,
Mhm. Go
I'm
ahead.
sorry. I'm sorry, Your Honor. We had filed a ex parte motion that we delivered to Sandy. I guess she could turn it over to you, and then we will, whenever it's ready, we'll get that order back.
Go
Mr.
ahead.
Spencer, I had forwarded the order to you and Mr. Valenzuela.
Got it. Thank you so much. You're always on top of it. Thank you, Sandy.
Yes, sir.
Thank you, gentlemen. Mr. Herrera, do you have anything else?
No, Judge, and then just to update the court, we're uploading the hand delivery slips for those forensic audios that were picked up on the 13th by
Okay.
both Mr. Spencer and Mr. Valenzuela.
And Mr. Herrera, let me ask you if I may inquire, Miss Detective Lara, there was one issue on one of the thumb drives. They were not sure whether that was actually downloaded on Portal. Detective Lara was going to verify that. Michelle wasn't sure at the time. Can you follow up unless you have an answer for us on that, please, and send me an email?
Yeah, I'll follow up with Ms. Hill. Let me see. Yeah, I don't think I have an answer unless there's something that was uploaded, but I can certainly follow up with that this afternoon.
Yeah, there was actually two items. One was a thumb drive and one was a SIM card. And they were not sure whether those had been uploaded because they were an actual evidence there, and they weren't sure whether or not it made it to Portal. I was requesting that I needed them downloaded or I needed a copy of them.
Okay, yeah, I don't see that those have been updated yet, but or uploaded yet, but I'll make sure that we either upload them or provide a copy for you all.
All right.
Thank you, Mr. Herrera. If there's nothing else, I think there was one matter that came up, gentlemen. We were inquiring about the spelling of your last names, both Mr. Martels. Is it one L or two?
Actually, mine is with two, and my brother's is with one. So that's
Well, there you go.
That's why.
Thank you for clarifying that for us. All righty. Mr. Spencer, anything else?
Nothing further, Your Honor.
Thank you very much. We will see you at the next setting.
Maybe
Thanks,
excuse, Your
gentlemen.
Honor?
Yes,
Yes.
sir. Thank
Thank
you.
you. Everybody stay safe. Thank you.
All right. So now let's go on Mr. Stevenson. Mr. Robert Stevenson, please, Annex. Thank you. Thank you. Sorry, we're with a Chewy substitute, Mr. Serna today, so I forget what I'm doing. So.
And Your Honor, I do see my victim advocate and the victim. We do have a victim impact statement for this one. So should they hang tight in the waiting room?
Come in. They can come in. Yeah. Mr. Stevenson, this is Judge Perez. Can you hear me okay?
yes.
Oh, beautiful. I can hear you just fine. Wonderful. Okay, so Mr. Roberts, are you ready to proceed?
Yes. Your Honor.
Okay, calling cause number 2020-0D04863, State of Texas versus Robert Louis Ogilvie Stevenson. May I have announcements, please?
Brian Herrera for the state of Texas, ready, Your Honor.
Charles Roberts for the defense. We're ready.
And the defendant, Mr. Stevenson, is appearing from the jail annex. Mr. Roberts, do you see your client?
I do, Your Honor.
Okay, sir, this is Judge Perez. We are set for a plea today. I will be asking you questions with regard to your plea, so I need to swear you in. If you would, please raise your right hand. Sir, do you swear or affirm that any testimony you provide will be the truth and the whole truth?
Yes, Your Honor.
Thank you so much. You can put your hand down, sir. Sir, what is, please state your full name for the record.
Robert Louis Ogilvie Stevenson.
Mr. Stevenson, I'm going to be asking you about documents you may have reviewed with your attorney, the first of which is marked as State's Exhibit number 1. Those are the plea papers in this case. Within that document, you're guaranteed certain rights, including the right to remain silent. the right to trial by jury, the right to counsel, the right to confront and cross-examine witnesses, and the right to call witnesses on your behalf and in your defense. Mr. Stevenson, do you recall reviewing State's Exhibit number 1 with your attorney and signing that document?
Yes, Your Honor.
And did you understand everything contained within that document?
Yes.
Mr. Roberts, have you had more than 10 days to prepare a defense in this case?
We have, Your Honor.
And did you explain the plea papers to your client?
I did.
Do you believe he has understood the admonishments, rights, and consequences of giving up these rights by entering a plea today?
I believe he understands.
Mr. Stevenson, are you satisfied with your attorney's representation of you?
Yes.
And Mr. Roberts, do you have any reason to believe your client is not presently competent to enter a plea?
I believe he's competent.
Mr. Stevenson, have you ever been found incompetent by any court?
No.
Have you ever been examined by a doctor or psychiatrist who has found you mentally ill?
Yes.
Are any of the conditions that are diagnosed or any other condition preventing you from understanding what we are doing today?
No, Your Honor.
Have you been able to effectively communicate with your client, with your attorney?
Yes.
Okay, so based on your testimony, your attorney's representations, and my observations of you, I'm going to find that you are competent to enter your plea today. Mr. Stevenson, are you a U.S. citizen?
Yes, Your Honor.
Where were you born?
Paso, Texas.
Okay, so in this case, there are 2 separate charges. First charge, count 1, is burglary of habitation. Sir, to that charge, what is your plea? Guilty or not guilty?
Guilty.
And the second charge is fraudulent use or possession of identifying information, number of items being between 5 and 10. To that charge, sir, what is your plea? Guilty or not guilty?
Guilty.
Are you making each of your pleas freely and voluntarily?
Yes, Your Honor.
I will find you are making your pleas freely and voluntarily. Mr. Herrera, would you summarize the evidence?
Yes, Your Honor. Had the state gone to trial on cause number 2020 0D0 4863, the state would have proven beyond a reasonable doubt that the defendant, Robert Louis Stevenson, on or about the 14th day of August 2020 in the county of El Paso and state of Texas, did then and there intentionally or knowingly without the effective consent of Joe Olivar, the owner, enter a habitation with intent to commit theft, and furthermore, did then and there intentionally or knowingly without the effective consent of Joe Olivar, the owner, enter a habitation and did then and there commit an attempt to commit theft. And furthermore, Your Honor, the state would have proven beyond a reasonable doubt that the defendant, Robert Louis Stevenson, on or about the 14th day of August 2020 in the county of El Paso and state of Texas, did then and there with intent to harm or defraud another and without the consent of Shelley Callahan and Joe Olivar, hereafter styled the complainant, possess 5 or more but less than 10 items of identifying information of the complainants, to wit, the name and date of birth of Shelley Callahan, a government-issued identification number issued to Shelley Callahan on a United States passport, a government-issued identification number issued to Shelley Callahan on a Texas driver's license, a financial institution account number issued to Shelley Callahan on a First Light Credit Union card ending in 8765, a financial institution account number issued to Shelley Callahan on a Chase Visa debit card ending in 7553, and a financial institution account number issued to Joe Olivar on a Chase debit card ending in 4675. At this time, Your Honor, the state would enter States Exhibits 1, 2, and 3, States Exhibit 1 being the plea papers, States Exhibit 2 being the Article 3914 disclosure form, and States Exhibit 3 being the case summary and indictment.
No objection, Your Honor.
Without objection, States Exhibits 1, 2, and 3 are admitted. What is the plea agreement?
Your Honor, it's 10 years deferred adjudication, $5,000 fine with $4,500 probated, 200 hours of community service, urine and breath analysis, curfew, court costs, tape evaluation, theft counseling, no contact with the complaining witness, Joe Olivar and Shelley Callahan, and no contact with co-defendant Abraham Vega, and all other terms and conditions that probation deems appropriate. And then also, Your Honor, this was discussed with Mr. Roberts. We will be dismissing the misdemeanor case, burglary of vehicles, 2020 0C07508.
Okay, Mr. Roberts, is that your understanding of the plea agreement?
That is my understanding.
And Mr. Stevenson, is that your understanding as well?
Yes, Your Honor.
Okay. Understand that the plea agreement is not binding on the court. Or if I were to reject it, I would allow you to withdraw your plea. If I follow the plea agreement, you may not appeal this case except on matters raised by written motion and ruled on before trial or by permission of the court. The next document I'm going to ask you about is a one-page document entitled The Trial Court Certification of Your Right to Appeal. It is a document that explains your appeal rights. Because this is a plea bargained or negotiated case, you do not have an automatic right of appeal. Mr. Stevenson, do you recall reviewing the trial court certification with your attorney and signing that document?
Yes, Your Honor.
Okay. And finally, the last document I'm going to ask you about is the motion for deferred adjudication. Mr. Stevenson, do you recall reviewing the motion for deferred adjudication with your attorney and signing that document?
Yes, Your Honor.
And Mr. Roberts, have you explained to your client both the benefits and detriments of deferred adjudication?
I did, Your Honor.
Mr. Stevenson, do you understand that if you violate a condition of your community supervision, I can proceed to sentence you up to the full range of punishment for these offenses? Do you understand that?
Yes, Your Honor.
And are you asking the court to grant you deferred adjudication?
Yes.
I will find there is sufficient evidence to substantiate findings of guilt. However, I will not enter findings of guilt at this time, and instead, I will defer further proceedings and place you on community supervision pursuant to the plea agreement for a period of 10 years. Let me ask, Mr. Roberts, are you appointed or retained? Okay, is there any reason to think, now your client is still indigent, correct?
Yes.
Okay, so for purposes of the fine, I am going to probate the entirety of the fine. What that means, Mr. Stevenson, is there is a $5,000 fine. However, as long as you are in compliance with your probation, they will not collect the fine, okay? That's what it means to have it probated. If for any reason you become non-compliant, they can come back and collect the entirety of the fine. In addition to that, you have to complete 200 hours of community service. You're subject to urine and breath analysis, curfew, screen for TAP, deaf counseling. You are to have no contact with the complainants Joe Olivar and Shelley Callahan, and you are to have no contact with the co-defendant Abraham Vega. Is there anything further, Mr. Herrera or Mr. Roberts?
Nothing further for the state, Your Honor, on the record.
Mr. Roberts?
Nothing from the defense.
Thank you very much. We now will be off the record on this case. My understanding is we do have a victim impact statement. So I don't know, Mr. Herrera, is it just one complainant or is there?
Your Honor, I don't know if they're both available, but I see Miss Shelley Callahan is logged in. I don't know if her husband is with her, but.
Okay, Miss Callahan, if you're familiar with Zoom, if you would please unmute. I'll leave it up to you whether you want to initiate your video or not. Can you hear us?
Yes, Your Honor. Can you hear us?
Yes, we can. Thank you very much.
My husband, Joe Olivar, is here as well.
Okay, so in whichever order you'd like to proceed, ma'am, you may proceed.
Your Honor, good afternoon. My name is Joe Olivar, and I am going to make a statement, victim statement, on behalf of both myself and my wife, if that is okay with you.
Absolutely, you may proceed.
Yes, ma'am. First of all, we would like to thank you, Your Honor, and everybody involved, especially our local law enforcement. They deserve a lot of credit for where we're at now. With that being said, I would like to start by saying how I view this crime. This was a blatant crime. It was a home invasion. It was an incredible, serious crime in which the outcome could have been tragically different. And we thank God, we prayed a lot. We thank God that no one was injured or killed, Your Honor. That was how serious this was in our mind, in our view. As we are aware, the law enforcement officer that arrested Mr. Vega, he was put in great danger due to the fact that Mr. Vega had a gun in his possession at the time of his arrest. A gun that was stolen from me. If something would have happened to that officer, I would have really had just sad guilt. So I just hope that Mr. Stevenson is listening right now And I hope he's had some time to reflect on what he was a party to. I had another weapon that night upstairs with me, and I reflect on what could have happened if I would have woken up that night and gone downstairs with that weapon in my hand. Things could have been completely different. Mr. Stevenson could have not even have been here today, and other things could have happened. I just thank God that things are where they are now. We believe in law and order, and we back our law enforcement 100%. But we also believe that the punishment, it must fit the crime. And we also, Your Honor, we believe in redemption of all people. I think the DA's office and Mr. Stevenson's counsel, if they've reached an agreement in this matter, we would like for the court to consider the impact it's had on us. We're the victims of this crime. But based on what we have learned from this individual, Mr. Stevenson, we understand he has had no previous criminal history. And based on this information, we believe that the settlement that the DA's office and his counsel has brought before you, Your Honor, we believe that the punishment does fit the crime. I want Mr. Stevenson to know we are not a people that seek vengeance, but we do seek justice. And we believe this young man, he has a chance to repent and start a new life. I hope he takes this chance that's been given to him. And I pray to God that he's able to repent. And I hope that if he meets the conditions set forth by you, Your Honor, this court, we wish Mr. Stevenson, we wish him well. And we hope that he could have a productive life going forward. And we hope this is the last time we have to ever be in a situation like this. Thank you, Your Honor.
Thank you, Mr. Olivar and Ms. Callahan. Thank you very much for being here today. I'm sure Mr. Stevenson, you would be well advised to take their comments to heart. I will add though, Mr. Roberts, so you know and your client knows, I don't recall seeing on the plea papers any restriction. I saw a no contact with the complainants. However, I did not see anything referenced, I'm assuming the residents. And so that will be part, unless there is some complication, you know, unless Mr. Stevenson is a neighbor or anything like that, there will be a 200-yard, not come within 200 yards of the, I'm assuming it's one residence. So that will be a part of the conditions, okay? All righty. Mr. Stevenson, your probation officer will go over with you, make sure you check in, stay in compliance. And with that said, we're adjourned on this matter. Thank you again to your complainants. Feel free to log off along with your victim's advocate unless they need to stay on for whatever reason. Mr. Roberts, if you don't have anything else, you're excused as well.
No.
Okay, thank you. Thank you, Mr. Stevenson. Good luck to you, sir.
Thank you, Your Honor.
Okay, so let me get I thought I saw Mr. Stevens, or is he gone? There he is. Mr. Stevens, your client, Mr. Pettibone, I did see the annex. If we could have is it Mr.? Yes, Mr. Pettibone, please. I did see your email. I just want to make sure we get this on the record regarding the bond hearing. So you all worked it out with the misdemeanors. Eventually, I guess this is going to be a dismissal. Is that right?
Yes, Your Honor.
Okay. Calling cause number 2021 0D00755, State of Texas versus Michael Lisseth Pettibone. May I have announcements, please?
Brian Herrera for the State of Texas. Ready, Your Honor.
Brent Stevens for Mr. Pettibone. We're ready.
And Mr. Pettibone is appearing from the jail annex. We're scheduled for an arraignment and bond hearing today. So your client is aware. I did receive communication regarding some resolution that I think ultimately will dispose of this case. And so, Mr. Stevens, you are waiving the bond hearing. Is that right?
Yes, Judge. I will attempt to get plea papers. As soon as I get plea papers, which I've already asked for them, I will take them to the jail and get Mr. Pettibone signed up. There's a time served direct on misdemeanors and then a dismissal of the 2 felonies.
Okay. So there you go, Mr. Pettibone. Your attorney will be in touch with you. It looks like processes are in place that only requires that ultimately we would get dismissals here. So if something doesn't follow that plan, we will see you at the next setting, Mr. Stevens. Thank you very much, Mr. Pettibone. Mr. Stevens, do you have anything else?
No, not today, Judge.
Okay.
Brian, would you mind emailing the misdemeanor attorney also, because I haven't received a response yet?
Okay, I will do.
Thank you. Thank you,
Well,
Judge.
thanks so much for working on that.
Yes, ma'am.
Okay. All right.
Judge, we do have the interpreter and Mr. Nunez online now. We do have an interpreter for a plea.
Okay, so that's Mr. Is it Bolivar? Let me see.
No. Yes, ma'am.
Okay,
I'm bringing in the interpreter now.
so we're missing some folks, huh?
Judge, I saw Mr. Dakota's in the waiting room. Oh, there he is.
Yes. The last three, Judge, are in the waiting room.
Judge Nunez, let me ask you really quickly. Thank you for letting us know, but I was hoping, and it kind of worked out. I was hoping to leave your client for last. Is that going to put you in, are you going to be in a better spot? Or is it going to put you in a worse spot if we wait on your client?
How long do you think it'll be, Judge?
$1 million question. I'm going to say 30 minutes and it's going to not happen that way, but I'm going to say 30 minutes.
Okay, that's fine, Judge. I can wait till the last.
Okay, thank you. I appreciate that. Oh, but we do
Yes.
have, Ms. Noyola, if you don't mind, please just waiting. We're going to take care of a couple of pleas first.
No problem, Your Honor.
Thank you, Ms. Noyola. Okay, so if we have Mr. Alba and Mr. Dakota is here, is that right? I don't see anybody. There he is. Okay. There he is. This was a carryover from last week, brother. Mr. Dakota, are you there? Mr. Dakota? Oh, he's
He's
connected.
connecting, Judge.
Mr. Dakota, are you ready on your client, Mr. Alba?
Yes, Judge. I'm
Okay.
here. Sorry about
Okay,
that.
great. No worries. Calling cause number 2018-0D01412 and 2020-0D06076. State of Texas versus Jeremy Alba. May I have announcements, please?
Brian Herrera for the state of Texas. Ready, Your Honor.
Proud to ghost Jeremy Alba. Ready, Your Honor.
And Mr. Dakota, do you see your client appearing from the jail annex?
Yes, Your Honor. I'm showing this is the status. Are we wrapping things up today?
We have it as a status and a plea. And so I
Okay.
did receive the corrected plea paperwork, and I think everything's squared away. It was
Okay.
a reset from last week. Mr.
Yes.
Alba, we have you down for a plea and a plea of true in these cases. I'm going to be asking you questions. So I need to swear you in. If you would please raise your right hand. Do you swear or affirm that any testimony you provide will be the truth and the whole truth?
Yes, Your Honor.
Thank you very much, Mr. Alba. You can put your hand down. We're going to start with the newer case, the 2020 case. My apologies. Would you state your name for the record?
My name is Jeremy Alba.
Mr. Alba, asking you about documents you may have reviewed with your attorney, the first of which is marked as State's Exhibit number 1. Those are the plea papers in this case. Within that document, you are guaranteed certain rights, including the right to remain silent, the right to trial by jury, the right to counsel, the right to confront and cross-examine witnesses, and the right to call witnesses on your behalf and in your defense. Mr. Alba, do you recall reviewing State's Exhibit number 1 with your attorney and signing that document?
That is correct.
Do you understand everything contained within that document?
Yes, Your Honor.
Mr. Dakota, have you had more than 10 days to prepare a defense in this case?
Yes, Judge.
And did you explain the plea papers to your client?
Yes, we've talked.
Do you believe he has understood the admonishments, rights, and consequences of giving up these rights by entering a plea today?
Absolutely.
Mr. Alba, are you satisfied with your attorney's representation of you?
Yes, Your Honor.
Mr. Dakota, do you have any reason to believe your client is not presently competent to enter a plea?
None.
Mr. Alba, have you ever been found incompetent by any court?
No, Your Honor.
Ever been examined by a doctor or psychiatrist who has found you mentally ill?
No, Your Honor.
Okay. Based on your testimony, your attorney's representations, and my observations of you, I'm going to find that you are competent to enter your pleas today. Sir, are you a U.S. citizen?
Yes, Your Honor.
Where were you born?
In Alpine, Texas.
Okay. So in cause number 2020-0D06076, the indicted offense is assault, family violence with a previous conviction. To that charge, sir, what is your plea, guilty or not guilty?
Guilty, Your Honor.
Are you making your plea freely and voluntarily?
Yes, Your Honor.
I will find you are making your plea freely and voluntarily. Mr. Adetta, would you summarize the evidence, please?
Yes, Your Honor. Thank you. Had the state gone to trial in cause number 2020-0D067-6, the state would have proven beyond a reasonable doubt that the defendant, Jeremy Alba, on or about the 10th day of September 2020, in the county of El Paso and state of Texas, did then and there intentionally, knowingly, or recklessly cause bodily injury to Liana Zamora, a member of the defendant's family or member of the defendant's household or person with whom the defendant has or has had a dating relationship as described by section 71.003 or 71.005 or 71.0021B Family Code by kicking Liana Zamora about the body and before the commission of the offense. The defendant had previously been convicted of an offense under Chapter 22 Penal Code against a member of the defendant's family or a member of the defendant's household or person with whom the defendant has or has had a dating relationship as described by section 71.003 or 71.005 or 71.0021B Family Code, to wit, on the 20th day of June 2019 in the 346th District Court of El Paso County, Texas, in cause number 2018-0D01412. At this time, Your Honor, the state would enter States Exhibits 1, 2, and 3, States Exhibit 1 being the plea papers, States Exhibit 2 being the Article 3914 disclosure form, and States Exhibit 3 being the case summary and indictment.
No objection, Judge.
Without objection, States Exhibits 1, 2, and 3 are admitted. What is the plea agreement?
Your Honor, it's 2 years confinement in the Texas Department of Criminal Justice Correctional Institutions Division. And that is concurrent with the revocation in 2018-0D01412.
Mr. DeCotes, is that your understanding of the plea agreement?
That's my understanding. If I can address you really quickly, Your Honor.
Yes, sir.
Yes, Mr. Alba has participated in some great programs and he has a lot of time. And he wanted me to address you on whether or not he has to, as they would say, make chain and have to go to the pen to finish things up, because I think he has the time. So if you could please, expound on that or whatever, Judge. Thank you very much.
Okay, I'm not sure procedurally, yeah.
I know.
The process is going to be whatever the process is. So whether you have the time or not, Mr. Alba, there's just certain things we are not going to be able to overcome. Okay, just know that. I do see here, at least as of the time I printed this docket, you have, over 300 days. So you'll just have to go with what the process is. With that said, Mr. Alba, is that your understanding of the plea agreement as well, what the state recited?
Yes, ma'am.
Okay, understand that the plea agreement is not binding on the court. However, if I reject it, I would allow you to withdraw your plea. If I follow the plea agreement, you may not appeal this case except on matters raised by written motion and ruled on before trial or by permission of the court. The next document I'm going to ask you about is the trial court certification of your right to appeal. It is a one-page document that explains your appeal rights. Because this is a plea bargained or negotiated case, you do not have an automatic right of appeal. Mr. Alba, do you recall reviewing that document with your attorney and signing that document?
Yes, Your Honor.
It was signed by your attorney and signed by me as well. So on your plea of guilty and the evidence introduced, I will accept your plea and at this time find the evidence substantiates your guilt. I will find you guilty of the offense of assault, family violence with a previous conviction, and I will assess your punishment pursuant to the plea agreement at 2 years confinement in the Texas Department of Criminal Justice Institutional Division. You will receive credit for any and all time that you have served, and of course that sentence will run concurrent with the next case we're about to go through. Anything on this case, Mr. Adetta or Mr. DeCotes?
Nothing further.
Okay.
Oh, Judge, thank you.
So as to cause number 2018-0D01412, Mr. Alba, are you the same individual who on June 20th, 2019, entered a plea of guilty and was placed on deferred adjudication? It looks like for a period of 10 years for the offense of assault, family violence, impeding breath or circulation. Are you that same person?
Yes, Your Honor.
And Mr. Dakotes, do you waive formal reading of the motion to adjudicate?
Yes, Judge, thanks.
And so, Mr. Alba, there were documents marked as States Exhibits 1, 2, and 3 that you may have reviewed with your attorney. They are waivers and stipulation in this case. Do you recall reviewing those?
Yes, Your Honor.
And did you understand everything contained within those documents?
Yes, Your Honor.
Mr. Dakotes, did you explain these documents to your client and the consequences of signing them?
Yes, Judge.
Mr. Alba, are you waiving the rights explained in the documents that you signed?
Yeah, yes, Your Honor.
You understand? Go ahead.
I'm sorry, it's because I do remember, but I kind of don't, but would the answer be correctly yes?
Do you want to speak with your attorney?
If I could have my attorney answer for me?
Well, he can't answer for you, but
Okay.
but he can answer questions, and I don't have a problem if you need to go into a breakout room and do that privately.
I hope we don't need to do that. I think we've talked about it enough.
Yes. I do remember now that, yes, I do understand.
Okay, you understand that you're giving up certain constitutional rights in those documents. Do you understand that?
Yes, that is correct.
Okay, you understand you're making a judicial confession?
Yes, Your Honor.
You understand that on your plea of true and all reasonable probability, I will find the allegations in the state's motion to be true. And in all reasonable probability, I will find you guilty of the offense of assault, family violence, impeding breath or circulation. Do you understand that?
Yes, Your Honor.
With regard to the motion to adjudicate, do you wish to enter a plea of true or not true?
True.
Other than the plea agreement, are you doing so because the allegations are true and for no other reason?
I'm sorry, Your Honor, I was unable to hear you.
Other than the plea agreement, are you, well, let me go back because now I'm forgetting. Yes, other than the plea agreement that you had with the state, are you pleading true because the allegations in the state's motion are true and for no other reason?
Yes, Your Honor.
Okay. And so the plea agreement here is again the 2 years TDC, Mr. Rivera?
Yes, Your Honor.
Okay, Mr. Alba, is that your understanding?
Yes, Your Honor.
Okay, I will accept the plea agreement. With respect to the state's exhibits, Mr. Detta, are you offering those into evidence?
Yes, Your Honor, we are.
State's exhibits 1, 2, and 3 are admitted into evidence. The court will take judicial notice of all documents in the district clerk's file in this case. But based on the evidence presented here today and on your plea of true, I will find there is sufficient evidence to support the allegations in the state's motion. And I will find you guilty of the offense of assault, family violence, impeding breath or circulation. The judgment is hereby amended from 10 years deferred adjudication to 2 years confinement in the Texas Department of Criminal Justice Institutional Division. Is there anything further, Mr. Dakotes or Mr. Herrera?
Nothing further for the state, Your Honor.
Just real quick, Judge, I want to thank the state. I think this is a great deal, a great offer. And Mr. Alba, his biggest concern was that he has all the time that he's legally allotted. And I think that the judge has agreed to that. And I want to thank you for that. Thank you, Judge.
Good luck to you, Mr. Alba.
Thank you.
Thank you, Mr. Dakotes.
Thank you, Judge. Have a great day.
You too. Okay, let's see. He's got 312 days on both cases. Okay. All righty. Is Mr. Parra here on Mr. Let's have Barnaby Chavez, please. I hope I got these right. And then we'll do Martinez, and then I think we can go on. Hello, Mr. Parra.
Hello, Your Honor.
Is someone there?
Yes, Your Honor.
Oh, okay. I saw a hand. That was weird. Okay. Oh, there he is. Okay. Thank you, Mr. Chavez. Okay, Colleen. Mr. Potter, are you ready? Yes?
Yes, Your Honor, right now.
Okay.
Thank you.
All right. Calling cause numbers 2021-0D0, 0712 and 2020-0D06487, State of Texas versus Barnaby Chavez. May I have announcements, please?
Brian Herrera for the State of Texas. Ready, Your Honor.
Your Honor, Manuel Barra for Mr. Chavez, also ready.
And Mr. Chavez is appearing from the jail annex. We're set for status conferences and bond hearings. Mr. Parra, you may proceed on your bond hearing.
Thanks, Judge. Before that, Judge, with respect to the status conferences, Mr. Herrera, for whatever reason, although we've requested access to the injury to child case that's been indicted, we've not been able to get that. So we're still kind of working on it. If there's some kind of an offer in that file, I'm not familiar with it. I'd very much like to know. That said, of course, from that point, I guess we can proceed with the bond hearing, court permitting, Judge.
So you said injury to a child, Mr. Parra. I have down, okay, see, here we go. Let's see, there's a P file.
Yes, Judge, there's also a P file one and a pending one. So two different.
Okay, let's see. Let me just look at this real quick. Barnaby Chavez bonds, $100,000. Corporate surety on each 0712 and 6487.
And you know what, Mr. Parra, I'm showing that
Yes,
you're not listed for whatever reason on portal as attorney of record.
Showing me as retained, but okay, I'll look into that.
Yeah, so but I'll look into it and I'll check with portal. But yeah, you don't show up, so that wouldn't make sense why you don't have access. So I'll make sure that that gets resolved. But yeah, on that 0712, you don't show up yet.
Does it list an offer?
And then
0712, okay, sorry, that's portal, that's different. Oh, what happened to Mr. Potter?
so it was the previous rec for Ms. Vergara was 2 years over 5 straight probation.
I saw that listed in this other case that I do have access to. I just wasn't sure if things might have changed as of the picking up of the new case. For what it's worth, Mr. Herrera, on the new case, it's my understanding. The police report reads very strangely. It almost seems like they're accusing him of keeping this young girl inside a house that he was babysitting and the cops being there. And apparently it's the situation that cops create that's treated in the report as the danger he's exposing her to. For what it's worth, there's a non-prosecution affidavit on the part of the father of the daughter who mentions not only was he trusted to care for her, but she ended up suffering more at the hands of the officers, apparently not only having to see while they beat him. Your Honor, and Mr. Herrera, you might notice that Mr. Barnaby Chavez is in a wheelchair, but in addition to that, apparently kept her in a cop car forever while she's just freaking out. So that's respect to the new case, Your Honor, and throwing that out there. Again, the police, insofar as the police report may be available to Mr. Herrera, again, it just reads a little strangely. With respect to the other two cases, Your Honor, yes, the bond is at $100,000, Judge. It's my understanding that he had been otherwise compliant, but of course, we're here to request that he be released on PR bond, Judge, and in consideration of that, for your consideration, Judge, he's been in El Paso about since the age of 14. It's my understanding he was born and raised in Los Angeles, but has been in El Paso ever since. He did not complete high school, Judge. However, he does have a job available to him, and he is very much looking forward to going back to that. His family owns a store that he's going to be employed at, Judge, and also he'd be living with his family. It's my understanding, Your Honor, he also has children in El Paso. They don't live with him, Judge, but of course they do have contact, and he does have those ties. More than anything, Judge, it's been our concern that Mr. Chavez isn't getting any kind of medical attention for the injuries received, and we're hoping to get him out on bond so that he can seek treatment for that. With respect to his history, Judge, I know he does have some priors, but it's my understanding that he has no TDC things, that we're not looking at any enhanceable offenses or anything like that there, for what it's worth. He has been in custody as of September 17th, Judge. And again, as far as the cases in your court, Judge, we're looking at $100,000 in each of the two cases, respectfully requesting a PR bond.
So I guess let me just make sure, in terms of the 100,000 on 0712 and 6487, so obviously we have a new arrest because there's a P file. Were those PR revels on those two cases, Mr. Barra?
That's my understanding, Your Honor, correct.
Okay, I don't recall. I was trying to look.
In your head, no, so maybe that's not the case.
Your Honor, I'm sorry. So Mr. Barnaby Chavez, at least on the 64871 one, was through One Stop. And this is where once upon a time, he was represented by Mr. Nevedomskis, and he was not checking into the Monday reporting. And so we then appointed Judge Hicks, and he did not report with his representation either.
Okay, so we had him not showing up to court under previous attorneys. Okay. And so that, is it for both of them, Sandy? Both the 6487 and the 0712?
Let me double check the 712, Your Honor, but 647 for sure. And
So did he miss court hearings, or he wasn't reporting to the bond company? I'm sorry.
It would
the
have
court
been
hearing.
here, I think, yeah.
Understood.
Yeah, it would have been here.
And it was for both, Your Honor.
It was for both.
Understood.
Yeah.
So we have a couple of different attorneys, Mr. Chavez not checking in. So that explains why we're at 100. What
Right.
were the bonds before that? Do we know that?
I'm not sure, Judge.
Let me get that, Judge.
So Mr. Butter, are you telling me he doesn't have any resources? Sorry, Marissa, any resources toward a bond?
No, Your Honor. I mean, his father was able to put together what he could for a retainer, but it's my understanding the family is otherwise pressed for money, Judge, and they're very much looking forward to him being able to help around the store. I know that's one of the things that's been keeping things slow.
Sorry, Marissa, go ahead.
Yes, Your Honor. I was just going to say it was 2,500 corporate surety on the case ending in 0712, and on 6487, it was also a corporate surety in the amount of 10,000.
10,000 on 6487. Okay.
Yes.
All righty. Thank you, Ms. Nieto. Okay. And then I got, is it, well, I don't want to ask that question. Go ahead, Mr. Reda.
Judge, so obviously Mr. Chavez has a history of not showing up to court in the past. So I do believe he poses a flight risk. He was MIA for some time. And then in this most recent incident, Your Honor, both the gang and SWAT unit showed up to the defendant's home, and where he barricaded himself and did not comply with law enforcement requests to give himself up into custody. So I believe what Mr. Parra was alluding to earlier, that this was a situation that was created by the defendant. He ignored commands to turn himself up. He had an open warrant. He was on the El Paso's most wanted list for a little bit of a while, Your Honor. So this was a dangerous situation that the defendant created. He does have quite a number of previous convictions, Your Honor. So given this situation, he both poses a flight risk and a danger to the community, Your Honor. He does have gang affiliation, so we would respectfully oppose the bond, Your Honor.
So hold on a second, Mr. Parra, are you opposed to any bond reduction, or is there a
Well, we're opposed to a PR bond, Your Honor, certainly, as he is a history of not showing up to court. And I believe in this instance, the bond has been reasonably set. We'll defer to the court as far as he obviously doesn't have resources to post bond, but we would definitely oppose a PR bond in this case, Your Honor.
Okay, go ahead, Mr. Parra.
And Your Honor, more than anything to Mr. Herrera, what I find strange is in reading the report, and I think you might agree with me, at first someone starts reading like maybe it's going to lead to some unlawful restraint, some kind of kidnapping charge, where the claim is he's not letting this little girl out, but ultimately.
Well, hold on, are you talking, Mr. Potter, are you talking about the 0712 case, or are you talking about the P file case?
It'd be the new one, Judge, just insofar as, the court may be considering how much of an impact a new charge or the severity of the new charge may have. And again, Judge, it's just strange to me because the report, is my understanding, never claims the defendant is directly causing any danger. It's more so the SWAT team ends up getting there, and now they're accusing him because of the dangerous situation they might have created in trying to apprehend him. It's just a little bit odd. I mean, it's not like the first one where there's some injuries involved and so forth, Judge, but again, for what it's worth, we have a non-prosecution affidavit in the works on behalf of the little girl's father, insisting that she was always okay and that if anything, it's the cops she sees as the bad guys, including
Mr. Barra, I think you're just going too fast for my court reporter. And
okay, I'm sorry.
For what it's worth, there we are. That's what you said. For what it's worth.
So let me go ahead and just stop it right there, because I don't really have the P file in front of me, right? I have the 0712 and the 6487. Are you telling me the 2021 case, is it the same charge or is it a different charge? I'm sorry if I missed that.
Your Honor, so the new P file is a completely separate charge.
Correct.
From this month, I believe. Actually, I'm sorry, it was September 16th.
And it is what? What is the new charge?
It is an abandoning or endangering a child. So
okay. And we have 0712, right, which is also abandoning and endangering a child. Is the complainant the same complainant in both cases? They're different complainants?
Yes, Your Honor. Different complainants.
Okay. And then obviously dates of offense from the unauthorized use and abandoning, those are different dates of offense, right? They're not related in any way.
Correct, Your Honor.
What's the alleged, let me see, what's the alleged date of offense on the 0712 case?
That is a 2019 case, Your Honor. January 8th, 2019.
1/8/2019, and it was indicted when?
If you give me 1 second, Judge, I will.
Sure.
March 24th, 2021.
Okay, so a little delay there. And then on the unauthorized use, date of offense allegedly is what?
October 10th, 2020, Judge.
2020, and that one gets indicted sooner, I would imagine.
That one gets indicted December 15th, 2020.
Okay. All righty. Okay, I'm sorry, Mr. Barra, did you have anything else?
No, Judge.
Okay. So with respect to each of these cases, I'm going to go ahead and reduce the bond to $50,000 each case in 6487 and 0712. Those will be split 40,000 cash surety, 10,000 PR. He is to report once a week to the PR bond office, subject to testing, use no illegal drug or alcohol. He has a curfew from 8 p.m. to 6 a.m. unless he is working. He is to have no contact with any of the complainants in his outstanding criminal cases. I'm not sure, I don't want to get too much in the details, but are there residence restrictions, Mr. Herrera, that would be useful here, or like, does he?
Your Honor, so my understanding that the child from the 2019 case is living with mother, so there's no residence restrictions as to that case.
Okay. All righty, so no contact, report once a week. You're to possess no weapons, Mr. Chavez. Let me think. What else, Mr. Herrera? Anything else?
No, Your Honor. That's all.
Judge, I'm sorry to interrupt. I don't have any future dates for Mr. Chavez. I didn't know if you wanted to put on a new trial track or not, ma'am.
Let's give them the May date that we have, May 6th.
Yes, ma'am.
Let me think. Okay, I guess that's it. I think that's it in terms of the conditions, once a week. Mr. Parra, if you need to come back or if you all need to discuss anything else, just let us know. We'll be waiting on the new case, I would imagine.
Yeah, and I'll go ahead and request that, Mr. Parra.
Thanks,
Then-
Mr. Herrera. I just, if there is another offer that you're looking to consider, I'll get you that letter anyway in the meantime.
Yes, sir.
Thank you. Thank you, Mr. Chavez. All righty. So then we have Crystal Martinez, please. And that'll be Mr. Barber. Thank you for your patience.
Anytime, Judge. Good afternoon.
Good afternoon.
Good afternoon, Mr. Barber.
Ms. Martinez, okay. Calling cause number 2020-0D04693, State of Texas versus Crystal Martinez. May I have announcements, please?
Brian Herrera for the state of Texas. Ready, Your Honor.
Daniel Barr for the defendant, Crystal Martinez, ready.
And Ms. Martinez is here appearing from the jail annex. I believe we're set for a final hearing plea deadline. This is one in which Ms. Martinez had recently pled, right? And this was like one case that was outstanding, or do I ever confuse?
No, Judge, we have not pled.
No?
I asked Mr. Herrera last time for an adjustment of the agreement because the defendant was seeking help. And Mr. Herrera never got back to me, but she doesn't want to go to Safe P. So I would ask if Mr. Herrera would like to take 5 years.
Yeah, Mr. Barber, I was just about to ask if you'd split the difference, so I can get you new plea papers on the 5, or if you want to just amend the ones, I can send you new ones, but it's up to you. You can amend the ones that I sent, or I can send you new ones.
Yeah, could you go ahead and send me new ones, please?
Sure.
We're going to reset the final hearing plea deadline then. It sounds like you all have an agreement. Final hearing plea deadline will be reset 1 week. We're going to just use that as our benchmark. Mr. Barber, you get your plea papers back to us in time. You can anticipate a plea on that date, but we need them, at least by Monday.
Okay.
Okay.
Mr. Herrera, would it make it easier if I did it for you, if I minute it? I know you guys are busy down there.
Yeah, I can adjust it pretty quickly because I think these are ones that I prepared anyway. So I'll do it this afternoon.
Okay, sounds good.
Back in 1
And
week.
Ms. Martin- Sorry,
We'll
Judge.
be back 1 week on a final hearing plea deadline. Go ahead, Mr. Barber, sorry.
Ms. Martinez, could you give me a call when you have a chance, please?
Yes.
Thank you.
Thank you, ma'am. Thank you, Mr. Barber. We'll see you in 1 week.
May I be excused, Your Honor?
Yes, sir. Thank you.
Thank you. Y'all take care. Have a good afternoon.
You too.
Yes, sir.
Okay, now I think we can take care of Mr. Bolivar. Ms. Marilla, thank you so much for waiting on this one. Was I
Yes, Your
about
Honor.
right with the time? I think I was. All right.
5 minutes early, Judge.
Really?
Yes, ma'am. I kept time.
I'm sure you did, Judge. All right, Mr. Bolivar. Okay, let's get set up with our interpreter.
Okay, so the function is on. If I could have everybody switch channels, please.
My son actually got a baseball scholarship.
Buenas tardes. Buenas tardes. ¿Sí se me oye bien la voz?
Okay, can I make sure, Judge Nunez, can I make sure I can hear you, please?
Yes, ma'am.
Got it. And Mr. Dada, I know you're probably on track. All right. So if we're ready, calling cause number 2017-0D03963, State of Texas versus Oscar Bolivar. May I have announcements, please?
Brian Herrera for the state of Texas. Ready, Your Honor.
Ruben Nunez on behalf of the defendant. We're ready as well.
And Judge, do you see your client appearing from the jail annex?
Yes, ma'am, I do.
Thank you very much. And Mr. Bolivar is utilizing this assistance of a court interpreter. Ma'am, would you state your name for the record? Thank you, Ms. Noyola. Mr. Bolivar, we are scheduled today for a plea in this case. I will be asking you some questions, so I need to swear you in. If you would, please raise your right hand. Sir, do you swear or affirm that any testimony you provide will be the truth and the whole truth?
Sí, es la verdad.
Thank you, sir. You can put your hand down. Would you state your name for the record, please?
Oscar Bolívar López.
Mr. Bolivar, I will be asking you about documents you may have reviewed with your attorney. The first of which is marked as State's Exhibit Number 1. Those are the plea papers in this case. Within that document, you are guaranteed certain rights, including the right to remain silent, the right to trial by jury, the right to counsel, the right to confront and cross-examine witnesses, and the right to call witnesses on your behalf and in your defense. Mr. Bolivar, do you recall reviewing State's Exhibit Number 1 with your attorney and signing that document?
Pues según lo que él me dijo, le entendí y lo firmé.
Okay. In addition to the document marked as State's Exhibit Number 1, there were additional pages, an additional 15 pages that were further written admonishments regarding your case. Do you recall reviewing that document, which I believe is in English and in Spanish? Do you recall reviewing the additional 15 pages with your attorney as well?
Pues en español no las leí porque no las miraba bien por la ventanilla, pero todo lo que me dijo el abogado, pues sí lo entendí.
Okay, so with respect to both State's Exhibit Number 1 and the additional admonishments, you were able to understand what your attorney explained to you, correct?
Sí.
And did you sign those documents after you had spoken with your attorney about them?
Sí, sí las firmé.
Judge Nunez, have you had more than 10 days to prepare a defense in this case?
Yes, ma'am, we have.
And did you explain the plea papers and additional admonishments to your client?
Yes, ma'am, I did, and I explained them to him in Spanish, in his native language.
Thank you, Judge. Do you believe he has understood the admonishments, rights, and consequences of giving up these rights by entering a plea today?
Yes, ma'am, I believe he did understand all of that.
Mr. Bolivar, are you satisfied with your attorney's representation of you?
No mucho, no al 100%.
Is there anything with respect to the representation that is giving you concern about proceeding with your plea today?
Repítame la pregunta.
So Mr. Nunez has been your attorney on this case and has advised you regarding your plea. You have now said that you were not, I guess, 100% on board with Mr. Nunez. Is there anything about your interactions with him that bring you concern or make you uncertain about continuing with your plea today?
En la última entrevista o durante el tiempo que me ha representado.
I mean the entirety of his representation. He has obviously been advocating for you and advising you. So I need to know before we go any further, if you are not at a point where you feel you have gotten the pertinent advice that you need regarding your plea today.
Sí me ha leído bien las hojas que firmé y me ha dicho todo. Pero yo pienso que ha estado conmigo defendiéndome, no me ha ayudado suficientemente, bastante bien.
Okay. Are you still wanting to go forward with your plea today? Or Judge, let me ask you, are you appointed?
I am appointed, Judge.
Okay. Mr. Bolivar, are you still wanting to go forward with your plea today?
Es que el señor Núñez me dijo que si no me declaro culpable a los 6 años, me pueden dar
Well,
más.
let me stop him right there. Mr. Bolivar, I need to advise you that the communications that you have regarding your case with your attorney are confidential. Okay, there is a privilege that is attached to everything you say to your attorney. So I would advise you not to speak regarding any conversations you had with your attorney about your case, because then you would be waiving your privilege. So before you go any further, I want to go ahead and I guess ask you again, if you are prepared. We are scheduled right now for a plea where it is anticipated you would be entering a plea of guilty to all 4 counts of the indictment in this case. If you are not prepared to do that today, then I need you to tell me now.
No, sí, yo soy culpable. Ustedes tienen la evidencia y la prueba que donde estoy yo haciendo lo que no debo hacer, pero las personas que me acusan de muchas cosas y no tienen pruebas.
So I am gonna stop the plea, Judge.
Yes, ma'am.
And before we get too far down the road, I'm gonna just go ahead and reset him for 1 week.
Yes, ma'am.
If there is an issue, if you find that there is an unsurmountable issue that presents itself, we will address it next week. If things somehow get more clear and we're able to proceed, we'll start again in 1 week.
Yes,
But
ma'am.
now, Mr. Bolivar, because of some questions, it's unclear to me whether you have questions or not. And I'm going to allow Mr. Nunez the opportunity to maybe review some things that I don't know if you're confused or you have a difference of opinion on. But we will be back in 1 week to either go forward with the plea or address whatever issues are holding up proceeding either with a trial or a plea in this case. Okay? With that, we will be adjourned on this matter. Judge, thank you for your help. We'll see you in 1 week. Thank you.
Thank you, Your Honor.
Ms. Noyola, thank you very much. Thank you, Mr. Bolivar. Is that everyone?
Gracias.
I hate being the bailiff, pretending to be the bailiff because I'm not always sure, but I think that's everybody. So, Ms. Noyola, I
Yes,
appreciate your time.
that is-
Thank you, Mr. Serna. That's what I needed.
We completed. I'm sorry, Judge. I was looking at tomorrow's docket. Sorry.
Oh, don't get ahead.